and what they're declaring for the purpose to be. So they automatically tell you off gate, there's an abundant evidence of the use of deceptive, abusive, and unfair debt collection practices. And that's led to personal bankruptcies. People losing their marriages, divorces are on the rise, people losing their jobs. And this is key right here for people to miss. It's a clear invasion of individual privacy. Because we're private people. We know that. But they force us into commerce. So since Congress said that's abusive, that's what they're doing. So what they found was the laws that were in place wasn't working because no one's getting remedy around here. And this, I believe, they enacted the FDCPA in 1977, if I'm correct. But before this was enacted, the laws that they had in place wasn't working. And that's why they said they weren't adequate to protect the consumers. So the purpose of this subchapter, Congress says it is a purpose to eliminate abusive debt collection practices. Now, Kareem, when you hear the term eliminate, what do you think of? Absolutely. So Congress has given us the power, and they tell us the purpose of this is to get rid of them. And that's why you've been seeing recently in the last few years, a lot of businesses just going bankrupt. Because people are understanding their rights, they're utilizing their rights, and they're getting them to settle. Because think about it, you say you've been in court, so you probably heard of settlements before. They want to settle out of court because 10 times out of 10, if you know who you are in the Title 15, they can't appear because what you're going to tell them who they are. So if they can't appear, they're going to settle with you. And if you go to court, they can't appear, you're going to get more damages. So that's the beauty of Title 15, because we as Moorish people, we know that we were the natural, original aboriginal people on this land. Aboriginal means nature. The nature means natural. Natural person means consumer. That's who we are. See, we've been speaking the wrong language, and this is what they gave us. So the term Bureau means the Bureau of Consumer Financial Protection. Now, you heard of the FBI. The FBI is the Federal Bureau of Investigation. They have a building, and they have agents on the ground they call the feds, right? Those are natural people. But who do you see on the ground for the Consumer Financial Protection Bureau? Who do you think that would be? Absolutely. Yes. So that's us, because that's our bureau. So that's why 3 says the term consumer means a natural person obligated or allegedly obligated to paying debt. Now, you know, since you've been studying, you know the controversy between the all caps and the lower caps name, right? So this, on number 1, this consumer starts with a capital C. We know anything that starts with a capital C is a person, place, or thing. We know what the birth certificate is. We know what that all caps entity is. So they're telling us what this is. As you just made sense of, we can be the only agents, which is a natural person. So we own that. Like, we're intertwined. So no one can tell you what to do because either one you are. You see what I'm saying? So you have the prime authority. When you see the term bureau out this chapter, they're referring to the power you have, because you're the only one that can own the consumer. Now, the term the term communication means conveying of information regarding a debt directly or indirectly to any person through any medium. So when we get to 1692C, they're going to talk about consent. It's going to tell you no one can communicate with you unless they have your direct consent. This is why this says directly or indirectly. So what they do indirectly, which we don't know, for example, if a sheriff comes to serve you at your home, that's an indirect communication about a collection of a debt, because he's listening to someone else. You see what I'm saying? So he's not getting it directly from you. He's listening to someone else and you owe a debt. So that's not direct, that's indirect. So this is why they're debt collectors, and when you go to the laws, you'll see that. But that's communication. So I always say, show me a law that says you have to pay a bill. Not because I can show you stuff that says you're not obligated to. And just by definition alone, on number 3, that's one of them. Because it says any natural person obligated or allegedly obligated to pay any debt. So as a consumer, not a U.S. citizen, if you're claiming you're a consumer, either you one of the two. Something's up for grab when they use or a sentence. Which one are you going to choose? I'm talking about as far as obligated or allegedly obligated to pay the debt. Absolutely, because that's what they told us from the beginning. We're innocent until proven guilty. So I'm allegedly owing this debt. That's what I'm consuming. So you can't just send me a bill. That's why sending you a bill is a violation. We'll get to that. So then it goes to say the creditor means any person. Let's click on that. Any person includes any state. That's all states. New York, North Carolina, whatever. But you know, if you go to the registry of deeds and you go get a copy of your certified birth certificate, It's from the state. And you know what that is. So when they say any person, they could be referring to you depending on the context. Instrumentality of a state, that's your cities and your counties. Then it says instrumentality of a state acting in his or her official capacity. Those are your attorney generals, secretary of state, and mayors, those public actors. Those are those people. Then it says any state and such instrumentality officer or employee shall be subject to the provisions of this chapter in the same manner to the extent as any non-governmental entity. So it's just about put everybody in one box under any person, state and everybody else, under the state, under the county, everybody, who offers or extends credit creating a debt. But by your knowledge and your mortgage history and the bankruptcy laws, who are the debtors of this nation? Absolutely. So they can't show you a law. So if they ever send you a letter, they'll say, we're the creditor. But they can't say they're the creditor pursuant to 69284. But you can, because it says the term creditor means any person who offers or extends credit creating a debt. Now, Kareem, when you go to the dealership, aren't you creating a debt? Absolutely. You're extending your credit creating debt because they're not doing it. So between that transaction is you and Toyota. So by default, you're the creditor by law. They can't rebut that. There's no law that says you're not. There's no law that says they are. So when you speak to them, you need to let them know, hey, I'm the creditor pursuant to 69284. Hey, I'm the consumer pursuant to 69283. Then it goes on to debt. Means any obligation or alleged obligation of a consumer to pay money arising out of a transaction in which the money, property, services, and insurance, which are subject to the transaction, are primarily for personal, family, and household purposes. Now, Kareem, everything you buy, isn't it always for personal, family, and household purposes? And that's a debt, and the creditor creates a debt. Once again, by definition, you're the creditor by default. Now, the term debt collector means any person. We went over that. That's everybody who uses instrumentality of interstate commerce. You know what interstate commerce is, correct? Right. So anybody doing business across state lines, debt collector. Then it says, or the mails in any business, the principal purpose of which is collection of debts. Now, you've probably heard people go get their EIN to see if they're a corporation, and then you'll know if they're not government and all that stuff. And they're not government. So if they're not government, what are they? Oh, they're a private corporation. No, they're not. They're debt collectors because it says the principal purpose of which is collection and debts. Think of the IRS. They're always sending out people garnishments, taking people student loans, whatever it is, they garnish and stuff. They always in the principal purpose of collection debts. So by definition, the IRS, it's a debt collector, right? Then it says who regularly collects. Who do you get a regular bill from? Right. And we thought we was calling them to get a service like they owe us something. And when they owe us something, they're not creditors, they're debt collectors. So and then it says who attempts to collect. And who do attempts to collect? If you was to get a parking ticket or a fine or so, that's an attempt to collect the debt, right? But if you go down, so you wait a minute, wait. You've been served, you said. You've been in court plenty of times. When they served you, did they say that you was a resident of, say, San Antonio, Texas, whatever, the city, you were a resident of such and such? How did you rebut that? You, as a consumer, the language you want to speak is what they give you, your location information. You don't have a residence, you have a place of abode as a consumer. So then by saying you're a resident, they're putting you as a United States citizen, which is not what you're defining yourself as. If you're defining yourself as a consumer, this is what applies to you and not residents. This is why I say that you have to speak their language, because under their terms, if you use their terms, you're playing their game. If they're not playing the game, you call them out and they're out. So, for example, these are only 8 terms at the state that they define under the FDCPA, Kareem. Now, one term is not here, Kareem, that you always see, and that's the term borrower. Don't they always call you a borrower? But they can't define it under the FDCPA because it's not here. So one easy way to get out of any contract was to ask them, hey, can you please define the term borrower under the FDCPA if you say I owe this? And they can't. That makes everything null and void. But that's the easy way. Why would you want to go out the easy way when you can see how they actually violate you? So those are only definitions under FDCPA. So remember, if they're calling you something or they're saying something when it comes to debt collection, that term is not defined, it doesn't apply. That's why Congress give you definitions, because they will call you anything else, but if you don't know what it is, then you don't know. Acquisition and location information. Now, any debt collector communicating with another person any person other than the consumer for the purpose of acquiring location information about the consumer shall. When you got served by the sheriff, you did not give that sheriff your address directly, did you? He got it from somebody else. So he communicated with another person other than you for the purpose of acquiring your address. That's why he came to your house. So the first thing they're supposed to do when they do that is identify themselves. Did they do that? No. State that he is confirming or correcting the location information. No, they just serving you and telling you, here's your papers. Then it says not state that the consumer owes any debt. Now, whether they say it or not, they're coming to serve you with, now it could be a different situation, but say if they're coming to serve you over a debt being owed. You're stating I owe debt. You can't do that. This is why the bill is a violation, because you called Kareem. I don't know if you called or your wife or whoever called and got the utility signed up. Did you tell them to send you a bill? You just said my electricity, electricity or water. But they did it anyway, not knowing that you knew you were a consumer and that was alleged debt, and you had to rebut this stuff. So now that you know you can't owe debt because they can't even state it. Why? Because it's always an alleged debt. Unless they send you proof that you owe it and the bill's not proof, you're not obligated to pay it by definition. Now, you ever got a bill a second time if you don't pay it the first time, Kareem? Did you tell them to send it to you? Not communicate with such person more than once unless requested to do so by such person. Or unless the debt collector reasonably believes that the early response of such person is erroneous or incomplete, and that such person now has correct or complete location information. So if you feel like I'm lying or whatever you feel like you have to send me a second bill, you better put it on the affidavit. I'm going to charge you $1,000. Now, you ever get a call, Kareem, and the first thing out their mouth is, this is an attempt to collect the debt, right? They just say that you owe debt. That's a violation. The first thing out their mouth is a violation. Then they say, can we confirm it? No, can we verify your name and address? Instead of confirming the correct, they want to verify. That's still the wrong thing. And they never identify themselves. So that's the first 30 seconds of the call, you missed $3,000 because each violation is $1,000. This is how deep this stuff goes. Same thing with the sheriff. If you're not there the first time, he's going to come back. You didn't ask him to come back. Just like they call you. You didn't ask them to call you back. You say, hang up, leave me alone. They keep calling you back. They communicate with you more than once, violation. Not communicate by postcard. Do you ever get a card in the mail from Rent Center saying that they're having a sale? Did you give them your address? They communicate with another person about you to get your address. That's a violation. They sent you evidence. So you have an exhibit to an affidavit that you can create and tell them that they federally violated you and they owe you $1,000. Not communicate by postcard. How did they get your address? You didn't give it to them. That's identity theft. That's criminal. Not use any language or symbol, any envelope, or in the contents of any communication affected by the mails. Or that indicates that the debt collector is in a debt collection business or the communication relates to the collection of a debt. Every letter you get that's saying this is on top, this is attempt to collect the debt, just like they said on the phone, correct? Violation, $1,000. Don't throw away your mail. If you got an attorney, they can't speak to no one but your attorney. That's what 6 is saying. But I'm sure you don't get attorneys. You represent yourself. That's right. Have you been collecting attorney fees? Oh, well, well, now that you have experience. See, let me get this back over here. I like to have people like you in the class. I don't know what just happened. Hold on. I did a split screen and it got to fix itself. These computers are so fancy sometimes. They do their own thing. You touch it once and it just do all types of stuff. They so sensitive. But this actually has a stylus. And my son lost my stylus, so I'm using my hand, so it's real sensitive. But I was saying something. We talked about acquisition location. Oh yeah, you're gonna be able to collect your fees now that you have the experience in court. That's what I'm saying. You're confident enough because you've been there and you've won. So now that this is gonna give you more leverage to get more damages because you're gonna see the other laws that entitles you to damages no matter what. So this is actually gonna be awesome for you since you have the legwork done already. Some people haven't even gotten as far where they're comfortable going to court. So if you're comfortable, this is just going to be your ammunition. I hate to give you this Uzi, but I have to. This is what you signed up for. Because this is exactly what it is. Because you can do some damage with this. You can really do damage with Title 15. So 15 U.S.C. 1692C. Communication with the consumer generally, without the prior consent of the consumer given directly to the debt collector. There it goes. I didn't give the sheriff direct permission. Also, you probably heard that do you have a license plate on your car? Is your car registered? Do you care about them pulling you over? Because you know what to do, right? But this is easier. I mean, not easier, but this just makes sense. Like, they have to have your consent. People say, well, don't get a driver's plate. Don't get this. Don't get a license plate. Why? Oh, well, they're jurisdiction. No, if you know Title 15 as a consumer, they got to have your direct consent. So Mr. Officer don't have my direct consent. He talked to the DMV after he put these numbers in his car, and that's what they told him. He didn't talk to me, so I could tear him up on the stand. So if you know what you're talking about, at the end of the day, they have to have your consent no matter what. So people going crazy over the Fed season, the Ancestry.com. If you don't have my direct consent, you can't use it. But if you're a consumer, you don't know that. You just think oh, they're the feds, they can do what they want. They're debt collectors. They attempt to collect the debt. You know what I'm saying? So if you know who you are, you know what to do. So cease and desist. Communication. A debt collector may not communicate with the consumer in a connection with the collection of any debt at any unusual time or place, which should be known to be inconvenient to the consumer. What time is inconvenient to you? Absolutely. So anytime they call, it's a violation because you didn't give them consent. They called at the wrong time. They said the wrong thing. They said it to you said I'm gonna add up $1,000 each. Adds up. But it says in the absence of knowledge of circumstances to the contrary, a debt collector shall assume. So you know what happens when you assume that the convenient time for communicating with the consumer is after 8 a.m. or before 9 p.m. But if you assume it's still a violation because I'm a consumer, it's inconvenient to me. Again, they tell you about the attorney. So that's why I like the FDCPA, because you can get a double whammy. That's not my phone, is it? Oh, you can they can get violated twice in all throughout the chapter. So if you had an attorney, if they violated you once with an attorney, it'd have been 2 over there in B and over here in C. So this is the same thing about the attorney. Now, I hear a lot about debt collectors or IRS, whatever, garnishing your wages or going to your job or communicating. They're not supposed to do that unless they have permission from your job. And that's what B3 is talking about. It says at the consumer's place of employment, if the debt collector knows or has reasons to know that the consumer employer prohibits the consumer from receiving such communication, the only way to know is to have it in writing. So if they don't have permission in writing, they're violating. Now, if the IRS sends your job some information to garnish and your job does it, then that means that your employer just became a debt collector because he didn't have your direct permission. Communication with third parties. Except as provided in 692B. That's the one we just went over. Without the prior consent of the consumer, given directly to the debt collector, or the express permission of a court of competent jurisdiction, that's only you, which is the Bureau, or as reasonably necessary to effectuate a post-judgmental remedy, or a debt collector may not communicate in a connection with the collection of any debt with any person other than the consumer, his attorney, a consumer reporting agency, if otherwise permitted by law, the creditor, the attorney of the creditor, or the attorney of the debt collector. Have you ever saw the FCRA? Have you ever went over the FCRA? Oh man, that's a good one. That's a good one. I was gonna bring it up, but if you didn't go over it yet, it'd be confusing. I don't want to confuse you, so I'll just leave that here. This is saying they can't communicate with anybody, basically. But what I was gonna tell you is the consumer reporting agency is not what you think it is. It's not Equifax in it. That's basically why if you go to the FCRA, they talk about that's a violation over here because they're lying too. Huh? Oh no, because it tells you in the FCRA. You ever heard that we don't have contact with these people like Equifax and them, right? But no one can ever prove it. But if you read the beginning of the FCRA under congressional findings, it says Congress said, hey, they developed this elaborate mechanism to think that they're important about consumer credit, basically. And we didn't give them authority to. So they're basically debt collectors. And they didn't have your permission because what? They had to have verified consent. So that's why they brought it back over here. So it all goes in. Title 15 talks about from these people collecting debt to these people saying who you are with your credit reports. It's all fraud at the end of the day. That's what the FCRA is, the Fair Credit Reporting Act. But that's communication with third parties. And one of the third parties is them agencies, but they're not who they say they are. So no matter who they communicate with, they have to have your permission at the end of the day. Now, have you been, I'm assuming you have you written cease and desist letters? And are they effective? Did they report it on your credit or anything? Like, is it all the way gone? Okay. Gotcha. Yeah. Because this is it. This is the ice on the cake right here. So cease and desist, I'm sure you've done it, but this is how they tell you. This is why I tell people you don't need a template, because they give you instructions word for word. You just have to read what they're saying and just put it into your own words. So this is your cease and desist template right here. If a consumer notifies a debt collector in writing that the consumer refuses to pay a debt, or that the consumer wishes the debt collector cease further communication with the consumer, the debt collector shall not communicate further with the consumer with respect to such debts. So they just told you can legally refuse to pay the debt. All you got to do is send them a letter. But when you send them a letter, the only thing that these people could tell you is to advise the consumer that the debt collector's further efforts are being terminated. But there's a semicolon there. That means in addition to that happening, something else has to take place. To notify the consumer that the debt collector or creditor may invoke specified remedies which are ordinarily invoked by such debt collector or creditor. So what's going to happen is they're going to say, you know what, Kareem, you're right. We're not going to collect anymore. We're going to stop. But if you don't know who you are, when you tell them to cease and desist, they're going to keep going unless you got some meat to your letter like you had on yours. So you have to invoke your remedy. They tell you it's a remedy here, but you have to invoke it or they will. So you have to tell them, hey, pursuant to 692CC, this is a communication to legally refuse to pay the debt. Pursuant to 692CC1, CC2, I'm invoking my specified remedy as a creditor. And pursuant to 692CC1, I'm asking that you terminate all collection efforts. You see how that worked? Like you invoked the remedy they said was there. You told them who you were. You told them who they were. So that means they can't rebut it if you're doing it on the affidavit, because you know affidavit stands for truth and compromise, word for word. So this is how they effectively want, it's not effective, but this is what they're giving you. But if you're doing what you're doing works, keep doing what you're doing. As long as you got, it's working for you, can keep on doing. But this is the federal laws that talk about cease and desist. So if such notice from the consumer is made by mail, notification shall be complete upon receipt. And I know you notice that things certified mail, but I've always wanted to know why, because the federal law says they like to play games. They'll try to, that's not what they're saying, but this is what I'm saying. They like to play games. If you send them a letter, give them 30 days, they'll wait till the 28th day sometimes and call you like, hey, I need more time. My secretary, she held on to it. And you're going to be like, no. Pursuant to 692C, you secretary signed for it because I'm looking at the receipt you signed for in a second. So they can't play those games with you, because they'll play those games. Because when you start speaking Title 15, they get scared. So because this is really important. Consumer defined. This means how you can be defined as a consumer. What other roles you can play. That's why I say you got to know who you are so many times. There's so many roles you can play. For this purpose of this section, so that means communication. The term consumer includes the spouse, the parent, if the consumer is a minor, guardian, executor, or administrator. Who's a minor when it comes to law? Well, really the dead people, right? The people that don't know who they are, right? So but those corporations, those are minors, right? So the consumer could be the parent if the consumer's a minor. So you are the parent of these people. These people that's in place supposedly. But then the executor. I've heard, you have to go file a UCC, claim your name back, go get the thing authenticated so you can be the executor of your estate. Well, as a consumer, you're already the executor. So that means if I'm a consumer, I'm the executor, I don't have to file anything because 1692CD told me to as a federal law. My personal opinion. As an administrator. Now, you know what the administrator is, don't you, Kareem? So that means you get to be the administrator. See, this is how cool this is, because if you understand who you are, you know you're doing your private administrative process as a consumer, as a natural person. But I'm going to let you know in this letter, Macy's, if I have to go to court and initiate action, I'm going to invoke my administrative role. And then I'm going to invoke my jurisdiction on the 692 case. I mean, you can't even move. You know what I'm saying? So you have to know who you are. So as you get to certain points when you're dealing with these people, you want to invoke a different role because you're going to need it. Because they're going to play it if you don't. Or they may take you to court and say somebody else's administrator. You see what I'm saying? So that's why. Exactly. So everything they're doing, we're supposed to be doing. But again, a lot of people heard of this stuff. They made theories, but we couldn't really prove it in writing. They couldn't find a set of laws. So this is really going to help them. So 15 U.S.C. 692D, harassment and abuse. I always talk about Rodney King on this one. I'm sure you remember the incident, Rodney King, back in the 90s. And there was a lot of controversy. And I remember I was a kid at the time. And they said, he should sue the police for harassment. And I didn't understand then. But now I get it. Because when we get to E, you already know, but when we get to E, you'll see how they call them out as their fraud. And since they're fraud, they really harassed them because that's what they did under this. And the amount of damages would have been way greater in any other law than this one. So that's why I know why they call it harassment with Rodney King. It says a debt collector may not engage in any conduct. Conduct is behavior. The natural consequence, which is to harass, oppress, or abuse any person in a connection with the collection of a debt. The following conduct is a violation. The use or threat of use of violence or other criminal means to harm the physical person, reputation, or property of any person. So just using violence, that's harassment and abuse. Just threatening to use it, violation. Anybody that's calling you a criminal, any criminal means, that sounds like it's police activity to me. Or if my car is getting repossessed and I'm trying to stop the tow truck guy and he's calling the police, you're trying to say I'm a criminal. You can't do that. I'm a consumer. That's harassment. And then they send you these letters and they try to talk all crazy and funky to you. Oh, if you don't show up or appear here, or if you don't pay this, we're going to do that. That's who you disrespecting. I'm a consumer. That's obscene and profane language. I could charge you $1,000 each word. So the use of obscene and profane language or language of natural consequence, which is abuse, the hearer or the reader. You get a letter talking about you're going to take my stuff. That's abuse. I could charge you for that. You tell me on the phone, you're going to do this and that. That's abuse. I can charge you for that. So this is all right. You can't they can't talk to you. They can't threaten you. I wish you would threaten me. You can't do that. It's harassment. Now, you've been to a courthouse before. So I'm sure on the first floor, you've seen it has a public notices and it has people's houses up there that's for sale, whatever, that they didn't pay, that's up for auction. Seen that before? That's a publication of list of consumers who allegedly refuse to pay debts. That's harassment in the courthouse because that's a publication because they say public notice and they say they refuse to pay debts. Allegedly refuse because we don't know. So in order to be a consumer, it has to be allegedly. So if that's in the courthouse, what does that tell you? Also, you have dockets. Then you have auctions. You have newspaper things. That's all harassment under federal law, and people don't even know they can literally get these people eliminated with using these laws. Now, I always say I always say foreclosure, repossession is legal. Here's the first half of it. The advertisement or sale of any debt to course payment of the debt. You can't force me and tell me if I don't pay, you're going to sell my house and sell my car. That's harassment. Can't do it. So this is the first half of it. You ever know but got anybody with a letter? They better write 1692D for rebutted and send it back. Causing a telephone to ring. Kareem, I knew you knew you was a god, but you knew they couldn't even call your phone. They can't even, that's a violation for making your phone ring. Why? Because they didn't have your permission. So they caused your telephone to ring. They didn't have permission. They called at an inconvenient time. They said you owed it. I mean, it goes on and on. I live in North Carolina, where it's a one-party state. I can record phone calls, not tell them. But I tell them anyway. When they say they're recording a phone call, I say I am too. Because I have my evidence against them since they're abusing me on the phone, whatever may have you. Because how else would you prove that they caused your phone to ring unless you have, you get print your phone records out. These phone companies crazy now. They don't do it like they did back in the days. They give you everything. So that's, how you will get them if you want this. But this happens all the time. They call you back to back repeatedly, continuously, with the intent to annoy, abuse, and harass any person. And yes, it's intentional. If I told you to stop calling and you didn't stop, I told you, And then they try to call you and they try to be your friend, Kareem. They're like, hey, Kareem, how are you? They're like, oh, this is attempt to collect the debt. That's a violation because it says the placement of telephone calls without the meaningful disclosure of the caller's identity. They can't even do that. Because 692B says they have to identify themselves first. Everything they do, violation, $1,000 each. Harassment. False and misleading. This is where they call out those rovers. It says a debt collector may not use any false, deceptive, or misleading representation or means in a connection with the collection of any debt without the limiting application. General application of foregoing, the following conduct is a violation. The false representation or implication that the debt collector is vouched for, bonded by, or affiliated with the United States or any state, including the use of any badge, uniform, or facsimile thereof. Who wears badges, Kareem? Absolutely. And uniforms, judges, right? And don't they say they have bonds? Mm-hmm. They say they affiliate with to them, the United States is the government. So they say they affiliate with the government and they work for whatever state that is. So the judge up there got a uniform on. He's sitting at a podium that says the state seal, and you can't call him out under this and you want to ask him for a FARA registration or a bar card? When you just got federal law say they not who they say they are because they got in a badge or a uniform. So if I was in front of, just why they won't let me in front of a judge. Because officer, you have is that a robe? Is that a uniform? Oh, okay. And that seal says North Carolina. And you work for the government. According to 15 U.S.C. 692E1, that's a false and misleading representation. There's nothing in the federal law that says otherwise. If not, I ask this case be dismissed. What do you think is going to happen? I know it's a little bit simpler than what you've been doing, but it's just nips it in the bud. You see what I'm saying? But you could use this in a letter to threaten the company, like, hey, if you go to court, this is going to happen. You know, but they can't show up anyway because E3 says the false representation implication that any individual is an attorney or that any communication from an attorney. There are no attorneys. So you let them know, hey, you can't show up anyway because corporations the law says you got to be represented by an attorney, and there are none. So in 692E3, you can't have one. So they can't even respond to you. Your bills. I always say, show me a law that says you have to pay a bill. You can't pay something in a positive amount. So Kareem, you're very smart. So if you open up your bank account, Kareem, and you had $1,000, if you open up online banking and it said $1,000, you know you got $1,000. But if you open it up and said negative $1,000, you know you owe the bank, right? Right. So negative means, and you know, just in 5th grade, 6th grade, negative and positive. Negative in front of something means you owed it. Is past tense versus present tense. So how can I pay something in a positive amount? That's a false representation of the character, amount, and legal status of a debt. You can't pay something if it's positive. The character is incorrect because it should be negative. The amount is incorrect because it should be negative. Can't pay something in a positive status. Impossible. I've never seen anybody do it. And it's funny because people are going in court saying that now, and the judge don't know what to say. How can I pay something in a positive amount? They don't know what to say. But that's the false representation of your bill. That's why they say everything's prepaid, because it literally is. It's already paid. But when we get to G, it's going to tell you it's already paid. But this is the first half of your bills being false and misleading on anyone asking you to pay a debt if it's in a positive amount, because you can't pay something in a positive amount. But if you look at your bank, and that's why I use a bank, because as you said, it'll have negative and positive, say debits and credits. So it's known that they can put a negative. So they'll probably say, well, I can't put a negative. Oh, I can show you my bank statement. You can put negatives all day. You see what I'm saying? And then if you pay a bill and you look at your statement and it say negative, what you paid, when it's supposed to be the other way around. You see what I'm saying? So that's a character amount, the false representation of. You can't pay something in a positive amount. Then it goes on to say, any services. What services? That's intangible economic output. What's intangible economic output? Sound like utilities? Any financial, insurance, transportation, any services you may need. That says a false representation of any services rendered, that means given, or compensation which may be lawfully received by any debt collector for the collection of a debt. What did that tell you, Kareem? That's fake. You can't collect. You can't do that. That's just one part of it. So we talked about 3, there's no attorneys. So again, if anybody getting sued, you let them know that if they're in the court right now, they can shut them down. Or if people say, well, where do I start? I said, we got to practice somewhere. I said, think about maybe if you ran a light something, or if you ever got in trouble and you got all these letters from a lawyer, just go find one of them old letters, because they said they was an attorney, and write them a letter, and you could collect your bag that way if you want to practice writing, because you want to learn how to write, because a lot of people don't know how to write. I know you know how, but some people don't know how to write. You know what I'm saying? So to practice, that would be the easy way if you've got some lawyer letters laying around, because they said they was an attorney. Start there. Easy bag. When I say bag, I mean money bag. I'm sorry. This is the second half of foreclosure. Can't go to jail for child support. All this stuff being illegal. The representation
Damn, I don't know if that guy's library is worth a $500 donation. I don't know. I don't think. I think I'd rather just ridicule the man for bringing credible information forward.